I'm Brad Hull. I'm an attorney with Kevin Hickey Law Partners. This is the 2-Minute Lawyer. Today's topic is consideration. So a contract generally requires three things: offer, acceptance, and consideration. Offer and acceptance are pretty common terms and they're pretty straightforward. Consideration is more of a legal jargony type of term that you may not have heard before. And if you're looking for definitions online like I did, you might find that you get a lot of answers. Generally, they're not contradicting or anything. They just have a lot of different ways to explain it, and that's because it's kind of a complicated subject. But generally speaking, what consideration means is it's the value that's getting exchanged in a contract. And so if you're just promising to do something, you might not have an enforceable contract, but if you get consideration involved in acceptance, then you do. And so it's often looked at as the benefit or the detriment that each party is agreeing to take on with the contract. An example would be if I went to agree to pay for a pair of shoes. If I said I would pay $50 in exchange for a pair of shoes, the consideration would be the $50 or the shoes, because I'd be giving up $50, they'd be giving up the shoes, and I'd be receiving the shoes, they'd be receiving the $50. There's a lot of kind of technicalities and loopholes that can come up with consideration. I'm not going to get into all of that right now, but kind of the key thing to know with it is that there has to be some sort of change of position. And so if your consideration is something that you're already obligated to do or something that you've already done, then you probably are not going to have an enforceable contract. It needs to be something that changes your position as you stand at that moment in time. And without that, you just have an offer and acceptance. You have a promise, but it's not necessarily an enforceable contract in the courts.